OB against Aventis Pasteur.
Mr. Leggett.
May it please the Court. I appear for the appellant APSA in this matter, unfortunately without Mr. Popat QC. Mr. Maskery QC and Mr. Preston represent the respondent.
Yes.
The case returns to this Court after a reference to the Court of Justice in what has now been a very long and protracted procedural battle over an issue of some general importance which arises in relation to the European Product Liability Directive. In domestic terms, the issue is whether Section 35 of the Limitation Act 1980 is applicable where the time limit is the period of 10 years provided for by Article 11 of the Product Liability Directive, after which rights conferred under that directive are extinguished. In more cosmopolitan terms, the issue is whether it is open to national law to allow a new party to be substituted as a defendant to a claim brought under the system established by the directive after the 10-year period has expired, and in circumstances where the person originally sued was mistakenly but incorrectly believed to be a person falling within the scope of the directive.
Yes.
That question, as your lordships know, was originally referred to the Court of Justice by the High Court. But unfortunately, the first judgment of the European Court gave rise to a dispute about what the Court had decided, a dispute which reached this Court in your previous incarnation. When we argued the point previously before you, it's right to say, I think, that Lord Hoffman, who gave the first speech, felt no doubt about what the Court had decided on the first occasion. But thanks to Lord Roger, if I may respectfully put it that way, your lordships were persuaded that there was at least a doubt about the matter and that the matter should be referred again to put it for clarification by the Court.
Yes. So we're now looking at the second element of guidance from the ECJ, and I think to bring the point to the real point for today's discussion, we're really concerned, aren't we, with the paragraphs from paragraph 50 onwards, where the Court is offering, as they say, some guidance to the referring court as to how they might proceed.
Absolutely.
And that guidance is in two parts, and the second part we needn't trouble with, because I don't think Mr. Maskery is making anything of that. So we're concerned with the first guidance.
That's
and
right.
It really is for us to decide, isn't it, what we make of it in the light of the facts which we have before us.
It is, my lord. And the starting point, however, in my submission is to identify what it is exactly, the general rule which the Court has established. Then, if I may, to explain what we say that guidance means and how it relates to the general rule. And then thirdly, if I may, I'll explain why in our submission the way in which the respondent seeks to interpret that guidance, we say is not a tenable interpretation.
The general rule is clearly stated for us in paragraph 49, isn't it, where it's quite clear that the Article 11 must be interpreted in a way that precludes national legislation which allows the substitution of one defendant to another, being in a way that is described in 49.
My lord, it is, and it's also to be found in 44.
And 62.
Yes.
And 62, and the reasons for it between 44 and 49.
And we've got it in the ruling as well. So that element is quite clear, and it must turn, mustn't it, on what we find as the guidance, which is then built on to assist the referring court in the light of the basic rule which is set out.
My lord, it is quite clear. There is one nuance, if I may call it that, about it, which I ought to draw to your lordship's attention, which is that the general rule which the court has clearly established in this judgment is different in one quite subtle respect from the interpretation which I was arguing for previously before your lordships. I took my argument on what the Commission had submitted on the first reference and what the Advocate General had opined on the first reference, and what I was seeking to contend the Court had accepted as being the position. The difference in what the Court has decided relates to the words "the producer" and the fact that, as your lordships appreciate, there can be a number of producers under the scheme of the directive. As your lordships know, there can be producers under Article 3.1, perhaps more than one manufacturer of the product. Your lordships have the Article 3 in the, perhaps most conveniently, in the judgment. If you have the
Paragraph
Court's
5,
judgment, or paragraph 5,
yes.
You can have more than one producer under Article 3.1. For example, if a manufacturer's manufactured a component part, perhaps somebody else has put their name or trademark on the product. And then you can also have people who are treated as the producer under Article 3.2 or 3.3, either because they've imported the product into the community or because they're a supplier who's failed to identify the producer within a reasonable time. So you can have a number of producers. But in Article 11, which you have beneath that on the page of paragraph 6, the words in the last clause, the proviso to the extinguishment of rights, applies where the injured person has in the meantime instituted proceedings against the producer, the singular definite article. So the question is, what does that mean? The Commission submitted on the first reference that it means basically a producer. So provided that proceedings have been brought against a producer, anyone who falls within any of Articles 3.1, 2 or 3, within the 10 years, the clock is stopped for all producers.
Including Articles 3.2 and 3.3.
Exactly. So to take this case as an example, the respondent is still arguing and has always made it it's always been one of his arguments that APMSD, the English company, is an Article 3.3 producer because it didn't identify its supplier within a reasonable time. On the previous interpretation, if that had been correct, it would have meant that suing APMSD within 10 years stopped the clock for everybody, and therefore, if it were established that APMSD were an Article 3.3 producer, it would be open to the claimant at any subsequent time to sue any other producer, for example APSA, and it wouldn't matter that the proceedings against APSA had been begun after 10 years from when the product was put into circulation. That was the Commission's interpretation. As I say, it was the Advocate General's. It was also the one, attaching myself to their coattails, as it were, that I was contending that the Court had decided, and one sees it reflected, for example, in the respondent supplemental case for this hearing today. If I can ask your lordships to turn in the bundle to that, near the start of the bundle, at paragraph 18, where my submission to the Court of Appeal is recorded. There's a quote from the Court of Appeal's judgment which summarises the interpretation which I was contending for and which I contended for also before your lordships.
Which I think I sort of followed, I think,
and
as a possibility.
My Lord Roger accepted that that was an arguable interpretation. But it is of some importance that it's not in fact the interpretation which the Court has adopted.
We're now tied to subparagraph 1. Is that right? 3.1.
3.1. Well, my Lord, their interpretation is essentially that the words "the producer" in Article 11 mean the particular producer, the producer in that producer. So in other words, the time limit operates separately for each producer.
Yes, a person who thought he was safe can't be sued outside the limit, basically.
That's right. Basically, it achieves more certainty on that interpretation because you know, if you're a producer, that if they haven't sued you within the 10 years, you're safe. as my lady puts it, because the 10 years, as far as you're concerned, have expired. And the fact that they have brought proceedings against some other producer is none of your concern.
Yes. Yeah.
And so there's quite an important difference, the importance of which I'll come to, between actually the way in which my learned friends in their supplemental case have summarised the court's ruling in paragraph 1 of their case, which is inaccurate, I submit, in one small but significant respect, in that what the court has established as the general rule is not that substitutions impermissible if it would allow proceedings to be brought against a person after the expiry of in proceedings brought within that period against a person who is not a producer, the last words there. It doesn't matter whether the person sued within the 10-year period was a producer or not. And that's not the formulation that the court has used in any of those various paragraphs that my lords identified, 44, 49, 60, whichever it was. What they have said is against another person. So it doesn't matter whether that other person was a producer or not. So to take this case, if APMSD turns out to be an Article 3.3 producer, that doesn't make any difference so far as my clients, APSA, are concerned. It allows the respondent a remedy, potentially, if he establishes that APMSD is a producer against APMSD, but it doesn't allow him to sue APSA after 10 years from when the product was put into circulation, subject to the meaning of the guidance, which I'm coming to, and I'm going to explain how in our submission that fits with this proposition. But the starting point is that each producer within Article 11 needs to be looked at separately. And that was clearly contended for in the Advocate General's opinion in this case. If I can just point you to the paragraphs where she analyses it in some detail. The relevant paragraphs are, in her opinion, 103 to 107.
Yeah, she begins by exploring the multi-layered element of the definition of producer earlier on in her opinion, and then comes on to it at 103. Is that right?
She does. It's a detailed and careful analysis, but at this particular part in 103, she's referring to the fact that, well, she starts by making the general point that bringing proceedings against one of several producers interrupts the limitation period in principle only in relation to the producer against whom the proceedings are brought.
Yes.
So it's exactly this point, and she develops that at some further length over the next few paragraphs. And it's important that when we come to see how the guidance given by the court fits in with this, but it is the starting point, and it explains why the court expressly said, when it giving its second piece of guidance in relation to Article 3.3, but that even if, as a result of that guidance, APMSD is to be classified as a producer, that will not permit substitution. That is what the court says, going back to its judgment. I'm sorry to go backwards and forwards, but in the judgment of the court, you find this at 61, I think it is.
Yes, I wonder if it's 56 as well, but anyway, let's see it in 61.
In 61, they expressly say that a finding, or the contrary finding, that's a finding that APMSD as a producer within Article 3.3
Yes, it would not.
would not,
Yes.
without infringing the directive, authorise upholding the application for substitution of APSA.
Yes.
And that is because they've interpreted Article 11, the reference to the producer, as applying separately to each producer. So that being the general principle which the court has established, the next question is, what scope, if any, does that still leave the respondent to argue that he can proceed against APSA, either by substitution or in a separate action? Because the court has taken the view that that amounts to the same thing. There are, in my submission, two ways, in principle, in which it would be possible for the respondent still to proceed against APSA if the facts were right for him.
And we're talking in this chapter now about substitution.
We're talking about substitution, but on the way the court has approached it, substituting somebody in an existing action is no different in principle from bringing a new action against them. In either case, you can only do it if you're still within time.
Yeah.
The first of the two possibilities is if your lordships will recall that there's a second proceeding that was begun in this case, a proceeding against APSA. It's recorded in the agreed facts. It was begun in October of 1990.
Well, no, it was 2002, wasn't it? Am I right?
Sorry, 2002, yes.
Yes, and it was...
I'm going back to 10 years.
Yeah,
2002,
that's right.
yes.
And you say that was about a month out of time.
Exactly, my lord. But the respondent has been contending until the significant concession that's been made in his case to your lordships for this hearing, but he's previously been contending that the product was not put, that those proceedings were commenced before 10 years from when the product had been put into circulation. And one got to there by saying first that the product was not put into circulation until it left APMSD and was supplied to the Department of Health, and that it's not in fact yet been determined when that happened, and there's uncertainty about it, and it might have been after October, the relevant date in October 1992. And if your lordships would look for this purpose at the agreed statement of facts, which is at the back of the bundle, at paragraph 10 on page 3 of that statement,
Yes.
it's agreed facts that on the 16th of October 2002, my lord says the separate action against APSA was begun. APSA's position is then set out that that was, we say, too late, but that has not been accepted.
Is that the last sentence of paragraph 11, Mr. Leggett? I mean, that I understood was your
Yes.
contention.
That's our contention.
But that's disputed, is it?
That has been disputed. All that has been common ground up to now is in 13, that the 10-year time limit had expired by the time the substitution application was brought the following March. That's the only common ground. And indeed, when we returned from Europe on the first occasion, my clients issued an application for summary judgment in the second action to argue that in the light of the court's ruling on question 1, which I'll be coming to on the first reference, on which the court ruled on when the product was put into circulation, it could no longer be maintained that the second action was commenced in time. But that application for summary judgment was resisted. It wasn't in the event argued before Mr. Justice Tier because he upheld the substitutions. He didn't need to decide the summary judgment. And he adjourned the summary judgment application and stayed the second action until after this issue has been, the substitution issue has been determined. But it has up to now been in dispute as to whether the second action was brought in time.
Yeah.
And if it was, then I would accept that under the court's analysis, it would also be possible to substitute in the first action if APMSD had wished to do that. Because if it were right that proceedings had been instituted against APSA before the 10-year period had expired, then the time limitation period would have been interrupted, the clock would have stopped. There's no extinguishment of rights after 10 years. And so if you want to substitute them in another action, you still could, because your rights against them haven't been extinguished by any effluxion of time.
Yeah.
And once again, the Advocate General analyses this and sets this out in her opinion. And I'll come to that in a moment, after I've identified, if I may, the second way in which, in principle, in my submission, it would still be possible for APSA to be sued. The first is if the product wasn't put into circulation until after 16th October 1992. The second way is if it could be said on analysis that APSA and APMSD, although separate companies, are the same producer, are a single producer. If that were possible, then it could be said that by bringing proceedings against APMSD within 10 years, there had been proceedings brought against the producer, meaning the producer which comprises APSA and APMSD. And in that case, it could be said that the clock had stopped for both APSA and APMSD, and that the respondent was free, therefore, after 10 years had expired, to proceed against either or both of them, whether in a further action or by substitution or joinder. How can that be when they're separate companies and European law, like every other system, recognises that the owners of a company are distinct from the company and it has separate legal personality of its own? The answer to that lies, as the Advocate General explained, in the first ECJ judgment on the first reference, in the answer which the court gave to question 1 on that reference, with which this court has not previously been concerned because it hasn't been the subject of dispute.
Excuse me.
But if I can ask my lords and my lady to turn to the first judgment of the Court of Justice, which is to be found towards the back, I think, of the
Yes.
bundle.
9th February 2006.
Yes, yes, my lord, yes. And turn to page 5. You see, first of all, at paragraph 17, the claimant's contention, the respondent's contention that the case is not statute barred. The putting into circulation didn't take place till it was supplied by APMSD to the Department of Health, and that occurred less than 10 years before the second action. So that's the claimant's case. And then question 1 was designed to illuminate the answer to that issue. And the court was asked whether the putting into circulation occurred on facts which are obviously meant to represent this case when it left the French parent company or when it left the English subsidiary company. And the answer which the court gave to that question starts at paragraph 20, where they identify the issue and the arguments. But the crux of their ruling starts at paragraph 27 on page 7, when they say that the product must be considered as having been put into circulation when it leaves the production process operated by the producer and enters a marketing process. in the form in which it's offered to the public. 29 then and 30 are crucial. When one of the links in the distribution chain is closely connected to the producer, for example in the case of a wholly owned subsidiary, it's necessary to establish whether it is a consequence of that link that that entity is in reality involved in the manufacturing process. The examination must not be influenced by the question whether or not distinct legal persons are involved. On the other hand, it is of relevance whether those companies are carrying out different production activities or are, on the contrary, companies, one of which, the subsidiary, acts simply as a distributor. It's for the national courts to establish, having regard to the circumstances of each case and the factual situation before them, whether the links between the producer and another entity are so close that the concept of producer also includes that latter entity, and the transfer of the product from one to the other does not amount to putting into circulation. And then they say that the fact that the products are invoiced to the subsidiary and it pays the price isn't conclusive, and nor is the question of which company had the ownership of the product. But, my lords, what the court was deciding there were three things in my submission. First, that there is no automatic rule of law when a company is transferred from a parent to a subsidiary, which tells you whether it's put into circulation when it leaves the parent or when it leaves the subsidiary. That is a question of fact, to be decided on the facts of the case. Secondly, the court has held that in order to answer that question of fact, it is necessary to examine the particular relationship between the parent and the subsidiary, and to see whether, by virtue of that relationship, it can be said, in effect, that the product remains under the control of the parent and is only put into circulation in the market when it leaves the subsidiary.
When you say relationship, it's actually referring to the factual nature of the transaction. I mean, obviously there's a transfer of possession from
Yes.
one to the other, but you're saying you need to see what in fact was what that transfer amounted to.
Exactly, my lord. That's what they're saying in my submission. And it may vary from one case to another.
And can I just be quite clear how you framed it? It remains under the control of the producer was the proposition. Was it?
My lord, yes. That the question is whether the relationship between the companies are such that it can be said effectively still to be under the control. The Advocate General, in her opinion, uses the expression de facto control of the parent until it leaves the subsidiary. And the third point is that, related point is that the fact that the companies are distinct legal persons isn't decisive. What matters is the actual functions which they carry out. And my lords, I can illustrate what in my submission the distinction being drawn amounts to by giving two possible factual scenarios, if I may, to contrast them. Suppose, first of all, that you have a group of companies which is operated commercially as a single organisation, effectively as one business unit. There are separate legal entities, perhaps different people working for the group have different companies which are their employers. When they sell products, they obviously invoice them in the name of one particular company or another, and they keep accounts and so forth. But in the way the business is actually operated, it's operated, is no doubt often the case in a group situation, as a single organisation. One person on the fourth floor is giving instructions to somebody on the second floor, as the case may be. That's one possible factual scenario. Contrast that with the case where you have parent and subsidiary being operated as separate autonomous businesses, simply that one owns the shares of the other. Obviously that gives it the right to replace the board of directors if it wishes, but in day-to-day matters, the directors of the subsidiary manage the business. It's not managed by employees of the parent company. It's left to conduct the business on its own, and it operates commercially as well as legally as a separate entity. That, I submit, is the sort of distinction that the Court of Justice had in mind. In the first of those cases, the single organisation case, one might say that the links between the companies are so close that they can in effect be regarded as one producer, and the nominal legal transfer of product from one to the other does not amount to putting that product into circulation in the marketplace. By contrast, in the second case, where the companies are functionally independent, the subsidiary cannot be regarded as the same producer, if it's a producer at all, and if its function is purely distribution, it won't be a producer at all. And so the product then will be put into circulation when it's transferred from the parent to the subsidiary. And what the court was saying on the first reference was, well, it's a matter of fact for the national court to assess the situation and decide into which of those factual situations this case falls. And according to the facts, the court can then find whether the product was put into circulation when it left the parent or when it left the subsidiary. There isn't, as a matter of law, an answer to that question. Could you take us on to paragraph 32, because
yes, that's quite important as well to understand the guidance which is given in paragraph 30. We have the last sentence in mind in paragraph 30, and then we look at 32,
yes,
which is the reply.
Yes. Well, the question is whether there is a point at which the product is transferred from parent to subsidiary can be said to have taken it out of the manufacturing process and into a marketing process. And that is going to depend, first of all, on what the subsidiary does. Does it do any manufacturing, or is it only a distributor? And secondly, on the practical, factual relationship and links between the two entities. So I would submit whether they are being operated as a single unit, in which case the legal transfer of title from one to the other isn't going to take the product out of what's regarded as still the manufacturing process, because it's being treated as remaining in the manufacturing process and not put into circulation until, on that example, it leaves the subsidiary.
If you look at paragraph 32, it could be read as directing attention to 2 points of time in the continuum. The first is taking out of the manufacturing process.
Yes.
Which, according to your timetable, took place at the very latest in, was it 16th of September 1992?
If you take the supply to the Department of Health as the point, the leaving of the subsidiary, yes.
Well, no, I thought it was.
That
was the date when it was sent to the distributor.
I'm sorry, my lord. Yes, no. On my case,
yes,
that's right.
I'm saying at the very latest, it was presumably packaged up, but it left the manufacturer, the producer, on that date in mid-September.
Yes, that's our case. Yes.
But the second date that I take from this moment is the entering the marketing process in the form in which it's offered to the public. Now, we don't know what that date was, but this would be the stage at which, or perhaps we do know, this is the stage at which the thing is actually presented to the public as a product which they can then purchase.
Well, when it says in the form in which it's offered to the public, I don't take that to require it to actually be offered to the public. It's simply to say it's got to have completed the manufacturing. So it's now reached the form of the product, which nothing else needs to be done to it.
Well,
because you can have
It's in its bubble pack
in its bubble pack.
So-
or whatever.
But it's in a form in which it can be marketed,
Yes,
is that it?
it's in a form in which it could be marketed.
And it's in the marketing process.
And it's in the marketing process, because putting into circulation basically means putting it into the market, or a marketing.
But if as I understand it here, if tablets or something went to a distributor, but the distributor then had to put them into bubble pack, whatever it would be, then it wouldn't have entered the marketing process.
It wouldn't.
in accordance with 32.
It wouldn't. And so that second entity, whether it's a subsidiary or not in that case, would be a producer as well. You can have a chain of manufacturers, each of whom is an Article 3.1 producer.
So can I just see if I follow that? I mean, one could envisage a situation where there was a large quantity of tablets which came in bulk from the producer to the distributor, and it was the distributor's function to break that down into packaging in the appropriate sizes of packets for marketing purposes. And the entering the marketing process would occur when the packaging was complete and it was in a position then to distribute in that packaged form. Would that be right?
Yes, well, it's a question of fact, I suppose, as to exactly what packaging is the form in which it's offered to the public. I mean, the fact that you open the box and the large box and take out the small boxes doesn't alter the form of the packaging. But if, say, you have to put a leaflet
Yes.
into the box or something like that, then it hasn't reached the form in which it's offered to the public until that's been done.
Well, that was the kind of thing I was envisaging. One's commonplace, you buy something across the counter in a pharmacist, and inside the box is the tablets, or
Yes.
the tablets plus the leaflet warns you about all the side effects if you actually are brave enough to take the tablets.
And that's part of the product,
Yes.
we accept. And so that would, if you put the leaflet in, you would be undertaking a part of the production
So is
process.
that, you would say that counts as what? Manufacturing a
Manufacturing.
component part? Is that what it is?
Manufacturing part of the product, or
By putting the leaflet in?
yes, because the leaflet is part of a pharmaceutical product,
And the box?
and the box,
Ditto.
ditto. Probably not the bubble wrap, but
No,
anyway.
but I meant the bubble pack.
Yes, the bubble
into
pack,
which the
yes.
tablets go.
Yes, indeed.
So
Absolutely,
inside
yes.
the box is the bubble pack
Yes.
plus the leaflet.
But probably even the box. I agree. The box in which the bubble pack comes, if it comes in a small cardboard box, which it then gets distributed. But my lord, one aspect of what the court is the court here is laying down, trying to give some general guidance on putting into circulation. And the question of when the leaflet's put in and so forth applies in any case. But the court is also directing itself in this first judgment to the particular situation where the distributor is a wholly owned subsidiary of the parent. That's the question that was asked about. And it's envisaging, as we submit, that the nature of the relationship, and this is really paragraph 30, between parent and subsidiary may be such that even though they're distinct legal persons, they may be regarded as a single producer by virtue of the closeness of the links between them. And I've tried to illustrate how that would operate, we say.
I mean, are there two points in here? I mean, maybe they're just opposite sides of the same point. One is whether or not the subsidiary, which is a distributor, is actually also to be regarded so closely tied up with the manufacturer, the producer, that it is to be regarded as part of the producer in effect.
Yes.
In which case here, that's how you say that they might be able to then sue through the parent company, because
Yes.
that would be, that's one issue. And
Yes.
the other issue is, at what date does it go into circulation?
Yes,
Is that
and,
right?
and whether the second company can be regarded as a producer, even if not the same producer, because it did something in the manufacturing process.
It all fits
But
in.
that's quite right. Those are two distinct questions.
It rather fits in with what we see in Article 3.1, doesn't it? Because the producer,
Yes.
as you say, has various layers to it as one works through Article 3.1,
Yes.
including putting the name, trademark or other distinguishing feature onto the product that's to be presented to the public.
Yes.
Well, there we are. That's what we found in the first.
Well, one then follows on. The way this works, I take you next, if I may, to how the Advocate General analyses this, which is, I will say, exactly the way that I have sought to expand it.
Yes.
And then show you that that is what the court is reflecting, albeit somewhat succinctly, in its first piece of guidance. My Lord, the Advocate General deals with this in her opinion. Well, I'll just show, my Lords, that because it's dealt with really quite some length, but really, first of all, on page 7 of her opinion, paragraph 33, she summarises and in this section, which I won't take up your Lordship's time by reading, but just point you to, is her analysis of the court's judgment on the first question. But then, and 39 to 42 as well.
Well, she says the issue is a factual question of the transfer of factual control over the product, doesn't
That's
it?
right.
That's what she says the test is.
That's what she says it is. And paragraph 39, she's identifying the possibility of that's where she uses the expression de facto control over the product might be retained by the manufacturing
So we
parent.
look at the last sentence, do we, of paragraph 39 in particular.
Exactly so, my Lord.
And paragraph 40.
And paragraph 40.
Paragraph 39 is interesting because it uses the word determine, which we're going to see in a moment or two in the relevant paragraphs.
Exactly,
in the
my Lord.
ECJ.
And so the last sentence of paragraph 39 is important, as my lady says, paragraph 40. She then goes into a discussion in 41 that there can be a presumption of control, which I will submit that part of her analysis was not accepted by the court. But she would have it that it's presumed that the parent retains control over the product, and the burden of proof is on those who contend it does not, to establish that in economic reality there has in fact, as well as in legal nature, there has been a transfer from parent to subsidiary. But as she would have it, there's a presumption which then has to be factually rebutted, but that part of her analysis, I will say, was not taken up. But it is the control test that she is finding in her analysis of the court's first judgment and setting up as being important to establish at what point the product was put into circulation. And then she, at paragraph 64, at paragraph 64, she identifies that the question of whether APMSD is a producer hasn't yet been finally clarified, and we pointed that out to the court at the oral hearing on the reference, and that the Commission submits that APMSD should be classified as a producer. So that's the background to the guidance that was given. There's an issue as to whether APMSD is a producer, either under Article 3.1 or 3.3. And then she suggests at 65 that the court can give some guidance,
Yes.
which is exactly what it did. Then 81, if we can move on to that. Well, 81 is just repeating the same. There's some certain repetition in parts of the opinion, identifying again that facts aren't yet clear and that guidance can be given. But then 86. Well, 86 is identifying that if the national courts in the end confirmed in the main proceedings that APSA and APMSD were so closely linked that APMSD couldn't determine its conduct autonomously with regard to the vaccine, then the vaccine would not have been put into circulation until APMSD sold it to a third party. And then she explains in 89 that the precise date of sale of the vaccine by APMSD to the Department of Health hasn't been ascertained, so there's an issue about that. But if it turned out that the proceedings were brought against APSA within the 10-year period, then if they were so closely linked that they had to be regarded, if the product wasn't put into circulation until after 16th October 1992, then the second action would still have been in time and substitution of APSA would therefore still be possible. And she has another excursus in paragraph 90 into the burden of proof again. But the 92 is the conclusion of that part of the analysis. As long as the limitation period under Article 11 has not yet expired, that's when APSA was sued, the producer can therefore, by means of substitution valid under national procedural law, be made a party to other proceedings in which claims for damages based on product liability have been brought by mistake against another undertaking. So that's the first of the two ways that I identified in principle that it could operate. Product not put into circulation until after 16th October 1992. Therefore, the action against APSA brought within the 10-year period. Therefore, the time limit against APSA hasn't expired. Therefore, you can substitute it in another action after that time, or continue the second action.
Yeah.
That's possibility number one. Then she goes on to identify possibility number, or analysis were number two.
That's head B, is it?
This is head B. And again, at paragraph 94, she emphasises that the classification of APMSD as a producer hasn't yet been decided by the National Court. And 95, she's referring to the fact that according to the first ECJ judgment, an entity which distributes a product falls within the concept of producers stricto sensu within the meaning of the first half of Article 3.1 if the producer and supplier are so closely linked that the producer, after transferring the product to the supplier, retains de facto control over the product transferred. If the national courts were ultimately defined in the main proceedings that there was such a close link, APMSD would consequently have to be regarded, together with APSA, as a producer. And then, down at the bottom of the page, she refers to the fact that such classification of APMSD as a producer would not rule out the bringing of proceedings additionally against APSA. Then she analyses the fact that I went to before, that in principle each producer is separate, and you've got to look at each producer separately. But then she qualifies that by saying that if APSA and APMSD are one and the same producer, because they're so closely linked, well then it will be possible to bring proceedings against APSA or substitute. And my lords, my lady, the critical paragraphs for this are 109 to 113 is the crux of this analysis, and these paragraphs are what we say the court is reflecting in its guidance.
I was really reading that chapter beginning at 108, actually. I mean,
Yes.
I think it's 108 to 113, isn't it?
My lord, yes, I may have
108
started
is very important.
a bit too far at 109. Yes. Yes, so bringing proceedings against a supplier cannot interrupt the time limit, but by contrast, 109, if the national courts were to reach the conclusion in the main proceedings that a supplier such as APMSD was, because of its involvement in the manufacturing process operated by APSA, to be regarded together with APSA as a producer, then the bringing of proceedings against one would interrupt the limitation period because they're the same producer.
Well, that's the point. I mean, 108 is saying you can't get in by being Article 3.3.
That's right,
But,
or generally speaking.
But provided you can get in into Article 3.1.
As the same producer, as the same Article 3.1 producer. I think her analysis would not extend, or at least to if you were quite separate Article 3.1 producers, doing your own thing, as it were, doing your own bit independently. It's completely independent companies. But if, because of the links between the two, picking up the first ECJ judgment, that they're so close that they can be regarded as one producer, then the time limit is going to operate in the same way for both of them. And 110, she's saying the decisive point here is the fact that a supplier who's sufficiently closely involved in the manufacturing process is to be classified together with the producer as a producer. Because those two entities are to be regarded in light of the functional interpretation as one producer, the limitation period must run in the same way for both entities. And then she refers to the court in the first O'Byrne judgment. The period runs the same way for both of them, and she says in 112 there must therefore be a uniform limitation period, and then 113 is the conclusion. Accordingly, my conclusion is that classification to be assessed by the national courts of the supplier as its producer has the consequence that that supplier is liable under Article 1 for the damage, regardless of whether he's a producer within 3.1 or 3.3. Classification of a supplier as a producer within the first half of Article 3.1 has the further consequence that the 10-year limitation period for the producer in whose manufacturing process the supplier is involved does not start to run until the time the supplier puts the product into circulation. At the same time, proceedings brought against that supplier will in that case interrupt the running of the limitation period in relation also to the producer in whose manufacturing process the supplier is involved.
Yes.
So if the two companies are so closely linked that they can be functionally regarded as one entity, that has two consequences. First has the consequence that the product's not put into circulation until it leaves the subsidiary, and the second consequence is they can be regarded as the same producer, and so the proceedings brought against one of them stop the clock for both companies.
It's interesting that she's putting it here in terms of the involvement of the supplier in the production process, whereas earlier on she was putting it in terms of the involvement of the producer in the supply process.
That's right. I suppose you can look at it both ways round if what you're looking at is that they're really operating as a single, functionally, as a single entity.
It was basically the control of the parent manufacturing company over the
Basically,
subsidiary
it is.
Distributing company.
Exactly. So, my Lord, coming finally, to the court's paragraphs, which are the subject of argument.
Yes.
Those are at paragraph 50 of the judgment of the Grand Chamber, down to 53. And what we submit the court is doing here in giving this guidance is, albeit, as we put it somewhat elliptically, is following the lead of the Advocate General and identifying the sort of situation which she has in mind and has explained could result in substitution being permissible. 50, they refer to the fact that they can give guidance, picking up what she said in paragraph 65 of her opinion. 51 is significant because it shows that the court is looking, at least potentially, at the time of putting into circulation as being when the product was supplied by APMSD to the UK Department of Health, because it's looking at that as being the time at which it was a wholly owned subsidiary.
So at that time, was at the time of the supply?
The time of the supply by APMSD to the Department of Health. And then it's saying, in such a context, it's for the national court, in accordance with the applicable rules of national law on matters of proof, to assess whether the putting into circulation of the product was in fact determined by the parent company which manufactured it. And what they are there contemplating is a situation in which the subsidiary has had possession of the product, but it's remained under the de facto control of the parent, so that it's the parent which is determining the putting of the product into circulation. Whether that is the case or not is for the national court to assess as a matter of fact, and in accordance with the applicable rules of national law on matters of proof. So the one thing they haven't taken up is the Advocate General's presumption and burden of proof points. They say that's a matter for the national rules of proof. But that's the question of fact in our submission, which the court is envisaging. Did the product remain under the de facto control of the parent, even when it was transferred into the possession of the subsidiary, so that it was only put into circulation when it was supplied to a third party, and that putting into circulation being determined by the parent? If that was so, then you could say that the parent and the subsidiary are the same producer, and that would enable you to say that proceedings had been brought against that producer when the original proceedings against APMSD were brought. And that would mean that when 10 years were up, there was no extinction of rights against either parent or subsidiary. And that would mean that notwithstanding the 10 years period has passed, APSA could still be substituted and proceedings thereby maintained against it by its substitution as a defendant in the original action. Or for that matter, the court hasn't gone into it, by a fresh action, by the second action.
Would it be right to, having looked at paragraph 52, to look back at the Advocate General paragraph 39? That last sentence in paragraph 39 where the word determined is used.
Yes.
Because that may cast further light on what the court are thinking of, or the Grand Chamber are thinking of. This a case where the supplier does not determine his conduct in the market autonomously,
Yes.
but follows the instructions of the producer by which he's controlled. You use the phrase de facto control, but one needs to
Yes.
understand a bit more about what's meant by that. Because obviously, if it's a wholly owned subsidiary, to an extent there is de facto control in some respects, but not necessarily in the marketing process.
No, my lord is right. It's the what they identifying as being important is as my lord says, that the control applies to to determine when the product actually leaves the production process and enters the marketing process. And my Lord, I also expect to adopt my Lord's reference to that sentence as further indicating that it's what the court has in mind, because it's indeed echoing the language there by reference to the use of the word determined.
Yes.
I'll be coming to it, but if all it meant was when the product, if the only relevant factor was whether the product was put into circulation by the parent, that's what it would have said, by talking about putting into circulation being determined by the parent, and that being in fact the case, and a question of fact to analyse whether that's the case or not. It's looking at it being in the possession of the subsidiary, but we say it's when it leaves the possession of the subsidiary, the fact that that is being determined by the parent enables one to view them as a single entity for this purpose, single producer for this purpose, putting the product into circulation at that time. And that's the nub of this guidance, and it's the only explanation of it, first of all, which corresponds to anything that anybody said in argument or elsewhere in the proceedings, reflecting as it does the Advocate General's analysis very closely. Otherwise, one has to suppose that the court is developing some guidance not based on any submission or on anything the Advocate General has said, and not, it must be said, supplying any explanation either of what the rationale of it is. But secondly, it's the only interpretation of it that actually makes sense within the scheme of the directive and of Article 11 as the court has interpreted it. Because, and I'm coming lastly in a moment to the respondent's interpretation, but there isn't any other interpretation that fits with the general rule and with the general principle that the court has established as to how this works, how Article 11 works, and what it means.
Before we come to look at the respondent's interpretation, yes, can we understand where you're taking us to? Because in your written case, paragraph 59, you say that the appeal should be allowed and the order substituting APSA should be set aside and the claimant's application dismissed. Now, yes, is there another, as it were, a middle ground here? In other words, it looks fairly clear from the way the court, the ECJ are looking at it, that they regard the issues of fact as unresolved.
Yes.
Otherwise, they wouldn't have gone into taking the trouble of giving the guidance, I imagine. And so far as they're concerned, the facts are not laid out in such a way that would make it pointless to give the guidance. So is this a case where an alternative route would be to send it back to the judge at first instance to look at the facts and decide whether the test that's laid out on your submission can be met?
It might have been, my Lord, might have been. This analysis has never been the way the respondent has put its case. It's always based itself on there being a mistake.
Yes, well, that's clear.
And, in fact, in their supplemental case, they have now, as we read it, conceded this point factually, so that there is no longer any issue about this, albeit
Where's that, Mr. Nick?
My Lord, that is at paragraph 4. Because it's now there said to be common ground, not only that it was APSA that manufactured the product, but that APSA determined the putting into circulation of the product when it was supplied by APSA to APMSD. So I take that to be an acceptance by the respondent that although there's never been any previous admission to that effect, that the putting into circulation of the product did occur when it was supplied by APSA to APMSD, and
Well,
therefore,
that's not necessarily what that sentence means.
No, I mean, it is referring to your own case, paragraph 51.
my lord, it is, but
3.
it says it's common ground.
You're saying that's an admission of what you say in paragraph 51.3, do you?
Well, my lord, my learned friend will explain it, but I read common ground to mean that he now agrees with that proposition. I couldn't otherwise discern why it should be common ground if he didn't agree with it. And he then goes on to discuss at some further, in paragraphs 8 and 9, that it would only be when it would only be put into circulation when it left APMSD's possession if that coincided with the date when the manufacturing process becomes complete. And he says it's not such a case. So he does not, as I understand it, in the light of the first ECJ judgment, maintain an argument that APMSD can be classified as an Article 3.1 producer and as part of the same producer. And he is indeed right about that, because on the evidence that we have served in the summary judgment application that was before Mr. Justice Tier on the first occasion, it explains that in fact this is a case where there are two companies operated as separate companies. APMSD did not put the leaflet or anything else into the product, so it wasn't a manufacturer in that sense. And it's a company which operates autonomously, operated and did at the time as well from the French company. And so it was not a case where they could be regarded as the same producer. But, my lords, as we read the supplemental case of the respondent, it's not being maintained that the product was put into circulation only when it left APMSD's possession. And that being so, the only guidance that the respondent is relying on is the second guidance. And that being so, we say that the result of this appeal must be to allow the appeal, set aside the substitution of APSA because there's no ground on which that can be maintained. And the proceedings would then continue against APMSD. The respondent is free to seek to rely on the second guidance to argue that APMSD is liable as an Article 3.3 producer. But my lord, certainly as set out in the supplemental case, it is being accepted, and indeed it's being positively argued that the Court of Justice can't have meant what we say it undoubtedly did mean, because there wouldn't have been much point to it saying that, because it's obvious that APSA and APMSD aren't the same producer, and that the product was put into circulation when it was supplied by the parent to the subsidiary. So, my lord, it's up to the respondent to identify it. He's never previously sought to justify substitution on that ground, and as we read his supplemental case, he's not seeking to do so now. All along, he's pursued the argument for substitution that because a mistake was made, and the wrong company was sued by mistake, Section 35 of the Limitation Act can be relied upon, and it applies in this context as well. And that's always been the issue. And all that he now accepts, as we understand it, as he must, is not available because the Court of Justice has on any view made it absolutely clear that subjective elements, as it calls them, matters of mistake, for example, cannot justify substitution. It's paragraph 48 of its judgment. My lord, the last aspect that I wish to address is the alternative interpretation which is proposed by the respondent.
Yes.
He says all this analysis is much too complicated. All that is required are two things. first, that proceedings were brought against a wholly owned subsidiary within the 10-year period, and second, that the putting into circulation of the product was determined by the parent. That's what he says at paragraph 3 of his supplemental case. And I think it's repeated at paragraph 22. So he says there are just 2 points. And the key point of difference between the interpretation which the respondent seeks to suggest and what we submit as the correct interpretation is that on his case, it's not necessary for the product to have been put into circulation only when it left the subsidiary, and that to have been determined by the parent. In his case, it's enough for substitution to be allowed that the product was put into circulation when it was transferred from the parent to the subsidiary, which he says is indeed the case here.
Well, he's saying you take the wording of paragraph 52 as you find it.
Well,
I
as
mean,
he finds it.
paragraph 21, or paragraph 3 indeed, is simply quoting verbatim, I think, the wording of paragraph 52, isn't it?
It's quoting it, but glossing it how it applies on his analysis. He reads determined the putting into circulation as essentially equivalent to putting into circulation. So that it's still for him a situation where the manufacturer has determined the putting into circulation of the product if it's done that by supplying it to its subsidiary, or to anybody else for that matter. As he reads it, the subsidiary doesn't have to have any involvement in the production or the distribution process. It can just be a subsidiary that's been sued, and if you've got that fact, and you've got the second fact that it was the parent company which determined the product being put into circulation, add those 2 together, that allows substitution. The fundamental objection to that analysis is it just doesn't make any sense as a matter of principle or reason as a legal rule, and it doesn't fit with Article 11 in any way. It would, in effect, be an arbitrary rule laid down by the court for which no reasons are given, and for which we would submit no reasons could be given because it simply doesn't make sense as an analysis of how the time limit operates.
So in the end, it comes down to really quite a short point, does it, as to whether you take the words simply literally as you see them in paragraph 52, or whether you are required to read them in the light of what the Advocate General was saying, which was clearly based on what was said in the first judgment in Auburn by the court in 2006.
Well, my Lord, in my submission it goes beyond that, in fact, because even if you look at the words themselves, actually, I submit, the better sense of the words is my interpretation. Because otherwise, the court would not have used the expression was in fact determined by. If my Lords have the paragraph 52.
Yes.
Not only, as I made the point to my Lords, do they clearly have in mind when they're embarking on this discussion, in paragraph 51, the supply by APMSD to the Department of Health as being potentially a critical point. But when they say that the question for the National Court to assess is whether the putting into circulation of the product was in fact determined by the parent company. Why have they used the words determined by? That indicates that the action, putting into circulation, is being performed by one company, the subsidiary, but determined by somebody else, the parent. That's the only reasonable sense to be given to that expression, particularly when, as my Lord Hope pointed out, it also tracks the language and analysis of the Advocate General. My Lord, secondly, the words in fact. Why have they said in fact? Because they're contemplating a contrast between the, as it were, superficial appearance of the matter, that it's the subsidiary that's supplying the product, and the underlying factual reality, which is that that is being determined by the parent, which is pulling the strings, if you like.
Do I gather that, because you're asking us to read paragraphs 51 and 52 together,
Yes.
Again, basing my question on paragraph 39 in the Advocate General, are you saying that one would need to find that the decision to supply to the Department of Health was on instructions given by the producer,
yes.
by the parent company,
yes.
I should say? That would be the critical point, would it?
That would be the critical point.
I understand that the difference is, just taking up that point, that you say the respondents would say it was enough that they'd handed over this batch
Yes.
and put it into the suppliers with the sort of general instruction that that this is going to be for supply, to be supplied. But you say that isn't enough. You say they've got to actually say that batch, which includes the defective box, should be supplied to the department. Is that what you're saying? Or is that not what you're saying?
Well, my Lord, I say that on analysis, applying the test in the court's first judgment, you have to come to the conclusion that the putting into circulation didn't occur until the product left the possession of the whole group, of the subsidiary, and that because the relationship between the two companies was such that the parent was exercising effective control over the product.
By product, are we talking about the box?
The box
of the particular box?
Particular box, that it's the parent which has directed the putting into circulation of the product. By giving instructions.
So, I mean, is the contrast between a scenario where the parent puts into circulation by transferring possession to the distributor, and in many cases that could be what one would regard as the change from production to distribution.
Yes.
You simply put it into the control of or into the possession of the distributor, who then distributes.
Yes.
You're saying to meet the requirements of Article 3.1, it would have to be the other way around. It would have to be that the circulation process didn't begin until it left the hands of the distributor.
Absolutely. That's the only way in which it can make sense to have the same time limit for APMSD and APSA, because the putting into circulation occurs at the same moment for both of them, and that moment can only be when it leaves APMSD, and that can be justified in terms of treating them as the same producer, because that's been determined by APSA.
And this is the point you're making in paragraph 4 of the respondent's supplementary case, because it does look as though the proposition there is that the point of time they're looking at is the time at which the product leaves APSA.
They're saying, as we read it, that they accept now that it's put into circulation when it leaves APSA, but on the court's test, that's good enough for them.
Yeah.
Because you read it as only requiring two, as it were, independent requirements. One, putting into circulation by the parent, and two, a relationship between the companies of parent and subsidiary. So, although it was put into circulation when it left APSA, the fact that the company sued was a subsidiary justifies you somehow in substituting the parent. On their case, as we understand it, it wouldn't matter what APMSD did. The product was put into circulation when it left APSA. Let's suppose it goes to quite a different distributor. But they then sue APMSD, a subsidiary company. They say that for some reason, because they've sued a subsidiary, and because the product was put into circulation by the parent, you can somehow add those two together and enable you to substitute the parent.
You say that, for example, even if APSA, or I got it the right way around, dictated, for example, the temperatures at which the product was to be stored, or to dictate the that they would put in, well, to take the temperature, let's say, at which it was to be stored, and so on and so forth, and the stocks which they had to hold of the product. None of that would, of these tablets, none of that would matter for this purpose unless, in addition to that, they also determined when that particular batch had to be put into circulation. Is that right?
Well, that is how we read the court's judgment, yes.
Because even if the first bit, I'm just trying to understand,
Yes.
even if the first things all suggested that they were part of the same organisation and to that extent were to be associated as the producer,
Yes.
on your analysis, I understand it, it's got to be the parent part of the producer which determines that when the product is actually put into circulation.
Well, I think that is what the court must be saying. I mean, it may be that the relationship between them is such that the parent effectively pulls the strings for everything. But even if that were not the case, what they're identifying as the critical point is the point of putting into circulation, and that being determined by the parent.
We are, of course, looking at this particular batch, aren't we? Because
Yes.
that's the one that caused all the problems for the individual. But the way Lord Roger puts it suggests there may be various stages in the timetable that one looks at. There's the receipt of the product from the parent company. There's putting it into storage if storage is required. There's a packaging of it in the bubble wrap and all the rest of it. And all of that could be occupying a period of time which takes one within the 10-year period.
It could on some hypothetical case. What you have to identify is the moment of time at which the product, under the court's first test, entered the distribution process in the form that it was going to be offered ultimately to the public.
Of course, we're not finding the facts, and
No.
that's one of the difficulties. But I think, so far as we're trying to think about this realistically at all, we're not talking about aspirins in bubble packs being sold over the counter. We're talking about a consignment of HIV vaccine, which presumably has quite a short shelf life.
Yes.
The wholesale value of which was £300,000, and it wouldn't have been sent over to this country unless someone was pretty sure it was going to be taken up by the Department of Health and distributed through hospitals. I mean, that's what we're talking about, isn't it?
Yes, well, all it is. And the question is, well, the factual question would be whether APMSD ran its own affairs and determined the time at which it supplied the product to the Department of Health, or whether that was determined by the parent. And on the facts, it was APMSD, because it placed the orders for the product it wanted, it decided what to sell to the Department of Health, and it simply ordered it from the manufacturer. But it could have been a different...
None of that is in the agreed facts.
No, it isn't.
It's in the affidavit evidence, which we haven't seen yet.
Absolutely, my Lord. And none of that has been ascertained by the court. But that would be, if there were a factual issue,
Yes.
that would be the factual issue which the National Court would need to determine.
Well, have we reached the point, really, where we ought to hear what Mr. Macri has to say, so we understand whether your interpretation of what he's written is, in fact, what he is actually going to be submitting to us?
My Lord, very nearly, if I may, could I simply just summarise very shortly my reasons why his interpretation is untenable, just to pull them together?
Yes.
There are 6 points, and I'll simply identify them, if I may. And I can do this quite shortly. The first is that his interpretation of the guidance doesn't, we say, make sense of the language used in the judgment, and I've made that point, the words, in fact, determined by the parent company.
Yes.
Secondly, it would leave nothing for the National Court to assess in accordance with its rules of national law on matters of proof, because on his case there simply wouldn't be any even potential factual issue. It's agreed that APMSD was the wholly owned subsidiary at the time of putting into circulation, and it's agreed that APSA determined the putting into circulation of the product. The only issue up to now has been what stage that occurred.
Yes.
Thirdly, my lord, there is no, we submit, principled, coherent or rational explanation for why substitution would be permissible on his interpretation. One would have to, in effect, treat the subsidiary and parent as if they were the same legal entity, which is not permissible under any system of law, relevant system of law. And even that wouldn't work, because he accepts it's a further requirement that the putting into circulation must be determined by the parent. That would be totally arbitrary on the way that he interprets the guidance. Fourthly, we submit that the suggested interpretation is impossible to reconcile with the wording of Article 11. And how the time limit operates under the wording of Article 11. He has to say that just because the company was a wholly owned subsidiary of the parent, it can be treated as the same producer. Even that doesn't work, because he's also accepting that it has to have been put into circulation by the parent. But how does that fit with Article 11, as to enabling you to treat proceedings against the subsidiary as if they were proceedings against the parent? It simply doesn't. There's no way you can match it up with the language of Article 11. Fifthly, in our submission, his interpretation is inconsistent with the court's judgment on the first reference, which made it clear that it does not automatically follow from the fact that one company is a wholly owned subsidiary of a producer that it can itself be classified as a producer, let alone the same producer, and that the test is a factual one which doesn't depend on whether separate legal persons are involved. So the court would have to be treated as overruling, in effect, its first judgment silently. And sixthly, my lords, it would mean that there is simply no reasoning anywhere to be found which provides an explanation of this guidance, because it wouldn't reflect anything that was addressed in submissions to the court, it wouldn't reflect what the Advocate General said, and there's nothing in the judgment itself which provides an explanation. We accept that the judgment itself is terse, but on our interpretation it reflects the careful analysis which is fully set out in the Advocate General's opinion. And my lords, for those reasons we say that that interpretation is untenable. Perhaps yet another reason is that it would, if one were going to look, if the fact that a company were a wholly owned subsidiary were relevant, as it were, in itself to the question of substitution, one would expect the relevant time to look at to be the time when the proceedings were begun. You'd want to know whether you sued at that time a company which was a wholly owned subsidiary of the parent. You wouldn't be looking at the time of production if you don't mind what the subsidiary's role in the production process was. You'd be looking at the relationship between the two companies when the subsidiary was sued. But, my lord, on the facts of this case, if I may just remind my lords, although APMSD was a wholly owned subsidiary at the time of putting into circulation of the product, it was not a wholly owned subsidiary at the time of commencing the proceedings. By that stage, it was owned in equal shares as a company by APSA and by another pharmaceutical company. And there will be all sorts of questions. Does it matter if it's wholly owned, 90% owned, 51%, 50%? None of that in our submission makes sense as any kind of legal analysis. The analysis which fits what the court says and must be what they meant is the one which the Advocate General has identified and which enables substitution only if they can be regarded as the same producer, and that can only be because the product, although put into circulation when it left the subsidiary, was put into circulation on the instructions of the parent. So, my Lords, for all those reasons, we submit that on analysis the court's guidance on this occasion is clear, and that it should not, in those circumstances, be necessary for your Lordship to refer the case for a third time to the Court of Justice.
How disappointing.
Thank you very much indeed, Mr. Maskery.
My lords, my lady, when we first went to Europe, it was to attempt to persuade the European Court that a product was put into circulation when the manufacturer lost control of it. The European Court rejected that argument and concluded that the product was put into circulation when it left the manufacturing process. Since then, we have looked at the question of substitution. We submit that there are effectively three circumstances which must be fulfilled before substitution will be allowed. First, the parent company must be an Article 3.1 manufacturer. Not sufficient if they are an Article 3.2 or 3.3 producer.
You're using manufacturer and producer interchangeably, I take it, are you?
Yes, when I say an Article 3.1 manufacturer, I mean somebody who has manufactured the product or who is taken to have manufactured the product under Article 3.1. Article 3.2 is an importer who may be regarded as a producer. Article 3.3 is the supplier who may be regarded as a producer. The guidance given by the European Court is restricted to circumstances where the parent company is an Article 3.1, as I've put it, manufacturer. Second, the Article 3.1 manufacturer must have put the product into circulation. If it hasn't done, it can't be liable under Article 7. And therefore there would be no point in substitution. And third, the person who was in fact sued must have been the wholly owned subsidiary of the Article 3.1 manufacturer. If those three conditions are met, substitution is permissible, and we say, as Lord Hope indicated, that those are the clear words of the guidance given between paragraphs 50 and 53 of the second judgment. If it is as straightforward as that, then we fulfill all of the requirements. The parent company was indeed the manufacturer under Article 3.1. It is not being suggested by Mr. Leggett that it did not put the product into circulation, and unquestionably the APMSD was the wholly owned subsidiary of it. If Mr. Leggett's interpretation of the guidance in paragraphs 50 to 53 is correct, then in effect he is inserting additional words at paragraph 52. Because what he is saying is that paragraph 52 should be read as follows. It is for the national court, in accordance with the applicable rules of national law on matters of proof, to assess whether the putting into circulation of the product in question by the subsidiary was in fact determined by the parent company which manufactured it. Because Mr. Leggett is saying, in effect, that where the product has already been put into circulation by the parent company, this guidance does not apply. And so he is inviting this court to take the view that the European court meant to say putting into circulation of the product in question by the subsidiary. And he develops his argument by saying that that has to be the case for this reason. The only way in which the subsidiary and the parent company can be viewed as one and the same is if the subsidiary is also engaged in the manufacturing process. And in effect, the parent company and the subsidiary have been engaged in manufacturing the drug. Because if the subsidiary is not engaged in the manufacturing process, then, because of the decision of the European Court on the first time round, the product will already have been put into circulation because it will have left the manufacturing process. So, what is being said is that the guidance only refers to a situation where the subsidiary has been engaged in the manufacturing process and the subsidiary put the product into circulation, but did so at the behest of the parent company.
So everything depends, does it, on whether after the words in question it's legitimate to insert the words by the subsidiary?
Yes.
Well, I'm speaking really rather off the cuff, but if you read 52 in the light of 51, 51 is asking one to have regard to a point of time, which is the supply of the vaccine by the subsidiary. So that is what we're contemplating, isn't it? And one might have thought it wasn't too difficult to insert the words that you object to in the light of what 51 says when one comes to 52.
I simply say that the words of 51 are referring to the fact that at the material time, the subsidiary must be a wholly owned subsidiary. And under 52, what Mr. Leggett contends for requires the court to conclude that it was the wholly owned subsidiary who put the product into circulation. And indeed, his whole argument is based upon that.
Well, you say there's a distinction between the word supplied in 51 and put the product into circulation in 52.
Yes, because plainly the product was supplied by the parent company to the subsidiary, but that isn't necessarily putting a product into circulation. Because I may supply that product to another part of the manufacturing process. Now, if it is right that Mr. Leggett is saying that the guidance is restricted to circumstances in which the subsidiary puts the product into circulation, then it must follow that the subsidiary is part of the manufacturing process. And if the subsidiary is part of the manufacturing process, then the subsidiary is an Article 3.1 manufacturer who has put the product into circulation. and therefore there will be a good claim against the subsidiary, and there will be no need for substitution. There will be no point to substitution.
Yeah.
So, my lords, we say that the guidance was not simply meant to be otios of no particular relevance or assistance. The guidance was there to deal with a particular circumstance that had developed in this case. And the particular circumstance that had developed in this case, where the guidance would be of assistance to the referring court, is where the product has been put into circulation by the parent company and comes into the possession of the wholly owned subsidiary. And in those circumstances, the court has held that provided that the subsidiary was a wholly owned subsidiary, and provided the parent company was the manufacturer, then substitution will be permissible.
I understand, sorry to interrupt you, but really in effect you're saying that Mr. Leggett's interpretation of your case is right.
Yes.
There isn't any dispute then as to what you mean in paragraph 3 of,
No.
of your written case.
What I'm saying is that if this was a case whereby the wholly owned subsidiary could be said to have put the product into circulation, then it must be a manufacturer. It would then be a defendant against whom the directive bites, and there would be no purpose in substitution. The guidance applies to both situations. The guidance applies to both the situation where it is clear that the manufacturer parent company put the product into circulation, and it applies to circumstances where both the subsidiary and the parent company put it into circulation, or indeed where the subsidiary put it into circulation but under the control of the parent company. The guidance applies to all those situations, not just, as Mr. Leggett would have it, the situation where the subsidiary must be regarded as a manufacturer. And to repeat, I hope only once, to say otherwise means that it's unnecessary guidance.
Well, at least you can say that it's quite plain from paragraph 53 that what the Grand Chamber were considering in giving the guidance was a substitution.
Yes.
I mean, that's plain enough.
Yes. And they are asking themselves the question, because clearly it's the central issue for the court. And it was referred to by Lord Hoffman in his speech, which the European Court had. In what circumstances can you regard the subsidiary as, in effect, the parent company? In what circumstances can you say that the proceedings were in fact brought against the producer? Answer: when the subsidiary is the wholly owned subsidiary of the Article 3.1 manufacturer. The alternative is to look at a situation when extraordinarily difficult and complex issues of fact will have to be analysed at great length in order to determine whether or not substitution could be permitted. If the court were, for example, to have used a simple control test, you can be regarded as the Article 3.1 manufacturer if you were under control of the Article 3.1 manufacturer. Then there would be many factual difficulties in determining whether there was control. So control was not an expression that the court wished to use. It wished to make it clear, and it did so by making it clear that it was a wholly owned subsidiary which mattered.
So what is the question of fact which, in this kind of case, the national court would be examining? I mean, let's take a case like this. What would it actually be deciding?
Well, the court will have to decide in this case whether whether the product was put into circulation at the determination of the parent company.
Well, that's just using the same words as is down there. What I want to know is, as a concrete thing, what is it that you're talking about?
Well, I'm talking about a situation in which the court has to determine whether or not the wholly owned subsidiary actually put the product into circulation itself without the parent company having dictated that. It has to make that decision.
When you say dictated it, what are you talking about?
Determined it. Made the decision.
I mean, are we talking about, is the question whether or not the parent company decided whether that particular batch should be
Yes, the national court has to make the decision that effectively the parent company put that batch into circulation. In other words, that it was the parent company that decided when and how that batch should leave the process of manufacture.
In other words, you're talking about just taking it in effect, taking it from France and putting it into the company in London. Is that right?
Well, that's the question of fact, isn't it? Because if the subsidiary company is involved in the process of manufacture, then the parent company, by supplying it to the subsidiary, would not have been putting it into circulation. And therefore, there is an issue of fact there to determine. The next issue of fact that will have to be determined, even if the subsidiary is part of the manufacturing process, is whether it was the decision of the subsidiary company then to put it into circulation by distributing it, or whether that was determined by the parent company. If it wasn't determined by the parent company, then no matter that the subsidiary is a wholly owned subsidiary, substitution will not be permissible. And so these are the questions of fact that will have to be determined.
I wonder whether, just to pick that up, we could look at paragraph 15 of the Advocate General's opinion.
15.
Paragraph 15, yes. This is where she's setting out the facts. And there's a narrative there of what APSA admitted. It admitted that it was a producer of the vaccine, that's clear enough, but then it said that the product had been put into circulation when it was sent on 18 September to APMSD.
Yes.
Now, you say, yes, that's right.
Yes. That is we argued initially that was wrong because we said it hadn't left the control of the parent company. But we have accepted that although it did not leave the control of the parent company, it did leave the manufacturing process. And it's the fact that it left the manufacturing process that means it's been put into circulation. And it was thus put into circulation by the parent company.
You say they decided
Yes.
to send it off to APMSD,
Yes.
and that was enough.
What we tried to argue before Europe was that because they retained control of it, they hadn't put it into circulation, and we lost that argument.
Yeah.
So what we say now is, well, we have to accept that it's been put into circulation, but we still say they've retained control of it. And because they've retained control of it, because they put it into circulation, they put it outside of the manufacturing process, they put it into circulation.
I'm not entirely clear what more facts need to be examined in the light of what is said in 52 and 53.
Well, the court has to come to the conclusion, as Mr. Leggett said, that when the product left APSA and went to APMSD, that was putting it into circulation. And at the time of the ECJ dealing with that issue, as is clear from the Advocate General's recitation of the facts, that was not something, that was still something that was in issue. And for example, the European Court did not know whether leaflets were to be added to the product by APMSD. And so the European Court was saying, in effect, yes, the issue is whether it left the manufacturing process. If the subsidiary is engaged in the manufacturing process at all, and we don't know, then you have to decide whether it was so engaged, and then you have to decide, if it was so engaged, who made the decision that it should then be put into circulation.
Yes.
And of course, it doesn't have to be the subsidiary that put it into circulation. For example, the subsidiary may supply the product to yet another company who is engaged in what may be determined as the manufacturing process, may supply it to a distributor who actually deals with the packaging and puts English language leaflets in. If that's part of the manufacturing process, then the question then is, was it then put into circulation? And again, who determined that it should be put into circulation? The independent third company or the Article 3.1 manufacturer? So, my Lord, I hope I answer the question. Are there matters that need to be determined by the National Court? Yes, there are. As we stand here now, I am accepting that the product was put into circulation by the supply to the subsidiary. But the European Court was making the point that that is a matter for national determination, depending upon what the facts are.
Yes.
No, so you're only accepting it for the sake of argument here. You're not accepting it as actually correct on the facts of this case.
Yes, I'm accepting it for the sake of argument here, because I say, if it has not been put into circulation at that point, and it's only put into circulation by the subsidiary, then I've got a perfectly good claim against the subsidiary.
You keep telling us it's very simple, but the trouble with this case is that the further you get into it, the more difficult it gets, because Article 11 assumes that in relation to any actual product which is said to have caused damage, the producer puts it into circulation. I mean, that's on the face of Article 11. At the same time, you go back to 3.1, a 3.1 manufacturer can be someone who only produces a raw material, which he is within the definition of a producer, but evidently he cannot possibly be the producer who puts it into circulation. And it does get... But there's no room, as I understand it, in Article 11 to say that the actual product is put into circulation by anyone other than a producer.
Well, my Lord, I'm not sure, because certainly that was the argument that the appellants were advancing, as Mr. Leggett accepts, and that was the argument that the Commission were advancing. And one asks this question, if we look at Article 11, if it must be read in this way, the producer put into circulation the actual product which caused the damage, unless the injured person has in the meantime instituted proceedings against that producer. If that's the way it must be read, then plainly it would mean that any Article 3.2 or Article 3.3 producer could never be sued. Because the Article 3.2 and Article 3.3 producer doesn't put it into circulation.
Well, if one's thinking about substitution, one has to look at paragraph 49 of the Grand Chamber's judgment, doesn't one, which makes it clear that if you're going to be substituting, you've got to look at Article 3.1. Is that not right? If you can get within 3.2 or 3.3 independently, then your action against somebody other than the manufacturer will be all right, provided it's within time, of course.
They restricted themselves to Article 3.1 manufacturers, and thus it means that if I had sued the wholly owned subsidiary of the importer instead of the importer himself, I can't use the guidance to support me because he's not an Article 3.1 manufacturer. But dealing with Lord Walker's point, the suggestion is now being made that actually time only stops against an individual producer if it's that producer who's put the product into circulation, because that's the way in which the appellant is reading Article 11, or says that the court is reading Article 11. But in truth, an importer and an Article 3.3 supplier doesn't put the product into circulation, ever. And so...
Not on this definition.
Not on.
And so it must follow that Article 11 can't be restricted to circumstances in which you bring an action against the person who put it into circulation.
I suppose the manufacturer of a component could be said to put it into circulation when they give it to the other manufacturer who then puts it together with something else.
Well,
It's left their manufacturing process. It may have gone into a different one, but it's left
It's
there.
the words, the actual product,
Exactly.
hard to square with that.
That's
Yeah.
right.
Yes.
Entirely impossible to square with it. Yeah.
but you can't square the Article 3.2 importer and the Article 3.3 supplier. And so, my Lord, when you were saying it cannot be really read in any other way, certainly the appellates and the Commission and the Court of Appeal in this country have done so, because the argument throughout has been based, until this morning, has been based upon the fact that Article 11 actually means a date on which a producer put into circulation the actual product which caused the damage, unless the injured person has in the meantime instituted proceedings against a producer. And certainly until this morning, that's how the appellants had argued their case, and we did not disagree with that. And I submit that that actually has to be how it's read. But I take my Lord Walker's point in that it can become yet more complicated. Because
Well, I don't want to make it any more complicated. I have to. I mean, I think the point that you've just been mentioning, I mean, is there, and it may have to be decided one day. But the point I was trying to make was actually a much simpler one, that unless there is some actual product which has at some point of time been put into circulation by a producer, then there's no 10-year limitation at all. I mean,
Right.
that is an essential component of how the limitation provision works.
yes, and it's an essential component of the ability to substitute that the person whom one wishes to sue was an Article 3.1 manufacturer. And in essence, what I say is that the European Court was concerned that arguing issues of control, for example, when making the decision as to whether substitution should be allowed, would be very complicated. And arguing issues as to whether there was sufficient control to say that the parent company or the subsidiary company put it into circulation would be very difficult. And there was much more certainty, which after all is what this directive is aimed at. If one says the exception is where the Article 3.1 manufacturer put it into circulation, made the decision that it should go into circulation, and the subsidiary was a wholly owned subsidiary. And to read it in any other way means, in effect, that the European Court was saying, well, yes, you are entitled to substitute, but in circumstances where you have no need to do so. My lords, my ladies...
Well, I suppose you could have a need to do so if the subsidiary had subsequently been floated off into a joint venture, as happened in this case, and had then gone bust, as hasn't happened in this
well,
case.
Well, that's why the recent discussion about the ambit of Article 11 becomes important. Because if the subsidiary has gone bust, but the interpretation of Article 11 is the way I suggest it is, then time has stopped against the original manufacturer in any event, and one would not need substitution because one could bring the action against that other manufacturer. In other words, I have brought my action against a company who put the product into circulation, who is regarded as a manufacturer because they were part of the manufacturing process. That has stopped time, and so if that company has become insolvent, I am then able to say, well, I can bring the action against another Article 3.1 manufacturer because time has stopped. If Mr. Leggett is right, then I can't do that. And the fact that I have sued an Article 3.1 company and 2, 3, 4 years after I've sued the company and I get judgment, I find that the company is in fact insolvent, I've lost all of my rights against the other producers. And we submit that was not what the European Court can have decided to have, or kind of wished to achieve by a sidewind, given that this was not something that was argued before them at all. It was, the submissions were made upon the basis that Mr. Leggett made his submissions to the Court of Appeal.
I suppose the virtue of your approach is to say, well, if you look at the ruling, which we find on page 12 of the Grand Chamber's judgment, that's a self-standing ruling. And you take the words as they're set out there as a ruling, and you don't have to burrow back into previous history. It's set out there without any reference back to anything else. It just stands by itself. And therefore, somebody who has no connection with this particular set of proceedings can simply take that ruling as it is and apply it to their own particular case without further investigation. And I think that's what follows from what you're saying. You're not putting that point forward as an argument particularly, but it does follow, I think, from what you're saying.
Well, I am putting it forward as an argument in this sense, that it is very dangerous to assume that the European Court was or was not relying upon particular arguments put forward by an Advocate General, particularly in circumstances where at the same time you're arguing that they didn't follow certain of the advice of the Advocate General. And the point was made by Lord Hoffman when this case came before the House of Lords, that if the European Court is going to make it clear where it does or does not follow the Advocate General, it will say so.
Well, very often it doesn't, I think, does it?
No.
And plainly, it would be very helpful if it did, but I don't think it does.
But in order to achieve, my Lord, the certainty that we wish to achieve, I do adopt what Lord Hope has said, and it is an important part of what we say, that one looks at the words in the ruling and one says that's what has been decided. It is not necessary for anybody, any company that wishes to determine when it will be liable, to then have to go back to the European Court's Advocate General's opinion and try and match the two. Look at the words. If the words appear to say what they do and are rational and are supportable, then that's what it means. And as I keep saying, it is rational and supportable because to put it in any other way would mean that the guidance given was unnecessary and pointless. And this enables limited companies to determine the circumstances in which they may be liable or that they may still be party to proceedings, notwithstanding that they have not themselves been sued. And it's making it very clear that the circumstances are extremely limited. And we're not going to get engaged in questions of control. We're not going to get engaged in questions of whether a 51% owned company does or does not have control. It has to be a wholly owned subsidiary. And it has to be the case that the original parent company put the product into circulation, otherwise it wouldn't be liable and therefore there is no point. And the third point at issue is that it has to be an Article 3.1 manufacturer. Why an Article 3.1 manufacturer? Because already, if one is bringing an action against an importer or a supplier, one is one stage removed. And to allow a subsidiary to a company that is one stage removed, who is sued, to permit substitution would be too remote, which is why they've restricted themselves to 3.1.
So I know it's not this case, and I don't quite know how it works. How does it work? How does a 3.2 person, an importer, how does Article 11 work in that situation, on your analysis?
On my analysis, time begins to run from the moment that the manufacturer, whoever the manufacturer is, has put the product into circulation. And
you mean when he's supplied it to the importer?
yes.
So,
And that's when time begins to run. The claimant will obviously not know that, and that's one.
But does the importer also put it into circulation?
No,
No.
no, it's been put into circulation. One could argue, I suppose, that it's put into circulation again and again and again.
Well, the importer can't ever be liable then, can they? Because of Article 7.
That's what Article 7 appears to say.
So why introduce them in the first place?
That can't be right.
My lady, one looks at Article 7 and wonders how can an importer or an Article 3.3 supplier be liable? Because they didn't...
Unless they are regarded as putting it into
Unless they are
circulation
regarded as putting
at the time when they decided
Exactly.
to put it on the market. And
And if they put it into circulation, each time they take an act, they're putting it into circulation. Then that's
well,
right.
time begins to run against them at a different point in time.
Yes.
It begins to run against the route manufacturer. That's not
Yes.
bonkers.
I'm sorry?
That's not bonkers.
No,
Quite rational.
no, I didn't suggest that. But what I'm suggesting is that time begins to run, the first time that time begins to run is when the manufacturer puts it into circulation.
Yes, against the manufacturer. But then time begins to run against the importer when the importer puts it into circulation. Now, admittedly, the definition given in this case of putting into circulation doesn't fit with what an importer does. But when that case comes up, perhaps Luxembourg will modify its definition.
My lady, my point, and it's the only point I make, is not to try and determine the answer to that issue, but really to deal with the situation that in this particular case, What the European Court was dealing with here was to try and determine in what circumstances, if any, some other entity can be regarded as the manufacturer. That was the central question. Can it ever be the case that some separate is regarded as the manufacturer?
And you say, well, a great deal of emphasis is put on the fact that this is a wholly owned subsidiary.
Yes.
And in the light of that, could we look back, I'm sorry to go back again, to paragraph 39 and 40 of the Advocate General, because it does strike me in the light of what you're saying that when one looks at the last sentence in 39, in that sentence, have you got it in front of you? It's probably...
I'm sorry, I'm just turning it up. Yes, thank you.
You see that last sentence, she said, that will be the case in particular where the supplier does not determine his conduct in the market autonomously, but follows the instructions of the producer by whom he is controlled. She doesn't actually say wholly owned.
No.
She's talking about control, and that could be less than wholly owned, of course.
Yes.
But then we come on to 40, where she gets into the idea of some kind of rebuttable presumption, but she is moving into a situation where she says that towards the end of that paragraph, it must not be overlooked, however, that transactions within a group, the transfer of a product does not normally involve a loss of control, especially where it's made by the product of a wholly owned subsidiary. So wholly owned comes in there, and you're saying to us, well, all right, there it is, but in fact the way the Grand Chamber have proceeded is to put that in the forefront of what they're setting out in paragraphs 50 to 53. If you do have a wholly owned subsidiary and the putting into circulation was determined by the parent, then that's it.
That's it.
And you don't get into presumptions. It's simply a proposition which you accept as a ruling.
And that's consistent with the fact that the first European Court did not accept our submissions that putting into circulation should be determined by reference to control. The whole point is that by using control as the mechanism by which one decides these questions, you are opening up significant and difficult factual disputes. You avoid that by simply saying wholly owned subsidiary. So it's consistent in that the European Court on the first reference would not use the control mechanism, and the European Court in the second reference has done likewise.
I thought your part of I'm sorry, I'm just not following the argument. I thought part of your argument was that when the parent manufacturer decided to supply it to the subsidiary, which is a distributor subsidiary, then at that stage, that was the determination to put it into circulation.
Yes.
Now, how does that square with the Advocate General's argument in paragraph 39?
It's because the Advocate General, at that point, didn't know whether that was an issue, considered that that was an issue that still needed to be determined.
Talks about after transferring the product to the supplier, was formerly part of the distribution chain. She seems to think you've got to retain de facto control of the product at that point. And then you go on, and because you retain de facto control, you decide when it is to be put onto the market. Now, your argument, as I understand it, is that once the manufacturer has handed it over to the distributor, that's it being put into circulation.
Yes, and that is what the
the decision to do that, you say, is the decision is the only relevant decision.
Yes.
But that's not what she's saying.
But, my lord, I agree, and what I was saying is that that is precisely what the European Court rejected.
Well, the point I was really
The
putting...
prospect of control being the arbiter.
The point I was really putting to you was really, I didn't put it quite as clearly, is really that paragraph 39 does raise an issue of fact about de facto control. But in paragraph 40, she's drifting in, I'm perhaps being rather, putting it rather rudely, but she's moving to the situation of the wholly owned subsidiary. And what I was putting to you is that the court, the Grand Chamber, have actually moved one step further with the wholly owned and said, well, that's good enough. If you have the wholly owned subsidiary and the parent takes the decision, which is the decision to put into distribution, then that's all you need.
I think I did understand.
You don't get into the question of what exactly is the de facto control, at what point did it begin, what point did it end, and so on and so forth.
That's my point.
But you've still got, on the Grand Chamber's ruling, a question of fact about determination by the producer. And if your argument is right, there is no fact to be determined because the producer has simply handed it over and that's obvious.
Not now, but my lady, at the time that the European Court was considering these questions, the European Court knew that the issue was when had the product left the manufacturing process. And at that point, the European Court did not know whether we would be arguing that it had still not left the manufacturing process when it was referred to the subsidiary. Didn't know that. It was a matter that was yet to be investigated. All the European Court at the first hearing said was, it's when it leaves the manufacturing process. By the time we got to the European Court on the second question, the court did not know what the arguments would be as to whether the subsidiary was part of the manufacturing process or not. As Mr. Leggett has made clear, we were served with material that has, which has meant that I am in a position now where I can say, we accept that the manufacturing process ended when the product was supplied to the subsidiary. But that was not what the court knew, and therefore, as far as the court was concerned, it was an issue that was still there for determination, and indeed will still need to be determined as such by the court.
Well, is there much more you need to say, Mr. Craig? I'm not quite sure whether there is, really. I mean, it may be puzzling to us, but it's. I think you've probably said as much as you can.
I'm not busting to tell you anything at all, my lords. No, those are the submissions that I would wish to make. Those are the central submissions, and insofar as they've been amplified, they're amplified in the case.
You don't want a reference either.
My lord.
It's not a wholly facetious question.
No, it isn't, because plainly, I would prefer not to lose. But in the context of a child who has had this litigation going for so long,
yes, you don't want another 2
I
3
can't,
years.
in truth, ask this court to prolong things any longer.
And you're not asking for it to go back either for a further finding, because you say you're now accepting the fact, which was, you say, still in the air at the time the matter was being considered by the Grand Chamber.
Absolutely. It would be pointless to do so.
So can you help me? What are you, from your point of view, asking this court to do?
To rule that the decision of Mr. Justice Tier and the Court of Appeal, whereby substitution is permitted, is consistent and compatible with the European Directive as interpreted by the European Court, and is thus permissible. There being no appeal against the exercise of the discretion that the judge used. The only argument that the appellant puts forward is it is incompatible with the directive. I ask you to say that it is compatible with the directive, and on that basis, the appeal falls and substitution will be permitted. My lords, those are my submissions.
Thank you very much. Mr. Leggett.
My lord, just 3 points, very briefly, if I may. First of all, my learned friend submitted that what we say is the appropriate and only reasonable interpretation of the court's guidance in paragraph 52 requires there to be read into that paragraph the words by the subsidiary when it says putting into circulation was in fact determined by the parent company, and that as we interpreted what the court meant was the putting into circulation by the subsidiary was in fact determined by the parent company. My Lord, we accept that. Our interpretation does require the court to read the guidance in that way. We say that is the only sensible way to read it, both in the light of paragraph 51, which precedes it, and because it's the only interpretation which makes any rational sense of the guidance which the court is giving for the reasons which I've already developed. My Lord, secondly, my Lord Hope raised the possibility that perhaps the court was just saying, well, we don't need to go into control, factual questions, it's just enough that there's a wholly owned subsidiary. That's good enough. My Lord, if that were so, there are many answers to it, but some of them are that there wouldn't have been a need for paragraph 52, which identifies an important factual question for the court to, national court potentially to have to determine. Second, it would be inconsistent with legal principle to treat a wholly owned subsidiary as the same person as the company. There's simply no warrant for doing that. Maybe one thing to treat it factually as the same producer, but you can't treat it as the same legal person, which that interpretation would suggest. And thirdly, it wouldn't fit with the fact that the court has on any view required as part of the test, and as my learned friend accepts, the putting into circulation as determined by the parent to be a necessary part of the conditions for substitution. And I won't repeat all the submissions I've made before as to the fact that that would simply be a wholly irrational requirement, incapable of any explanation which ties it to the words or the purposes of Article 11, unless what the court is dealing with there is the situation where the putting into circulation has been done physically by the subsidiary, but determined by the parent. That can be the only reasonable justification, or the only possible justification for treating them as the same producer. So, my lords, for those reasons, we say the only reasonable interpretation is the one that we have commended to my lords. My learned friend said that if that were correct, then there would be no point in this guidance being given, because what would be the need to substitute the parent for the subsidiary if they're both producers and can be sued? My lord, two answers to that. First of all, the court is concerned with the legal analysis, not with whether in practice it's an advantage to substitute one person for another. But secondly, the answer that my lady gave, which is that one could envisage circumstances in which, for example, the subsidiary has gone bust, and when one might want to substitute another company for it in the proceedings in the same group. My lord, the last point that I was going to address was the disposal of the case, but I understand my learned friend to accept that if your lordships regard our interpretation of the judgment as correct, then it must follow that the appeal is allowed, the substitution is set aside. Of course, that leaves him free to maintain his claim against APMSD based on any arguments he may wish to pursue against APMSD about its role as supplier or otherwise in the process. And I do finally remind my lords, my lady, once more that the issue which has detained courts here and in Europe for the last 6 years has been entirely an argument about the question of mistake and Section 35 of the Limitation Act. That is the only ground on which substitution was actually sought and has ever been sought. And one thing that we're all agreed is clear from the judgment, is that that question has now received a clear and conclusive answer. Those are my submissions.
Well, the court is extremely grateful to counsel for their submissions this morning and the very helpful way in which they've been presented, and for their submissions in writing as well. The court will take time to consider its decision.